General Counsel for Governor Bush, and Ed was on the Judicial Nominating Commission in South Florida at the time, where he had a reputation for asking good questions and being quite honest, both with the candidates and about the process with us. He served a total of 10 years on 3 different judicial nominating commissions, including as Vice Chair and Chair of the 15th Circuit JNC and the 4th DCA JNC. He was a Vice Chair of the JNC Rules Committee for the Florida Bar and the Chair of the CRC, that is Constitutional Revision Commission Subcommittee. He managed to do all this while maintaining an extensive trial and appellate practice at Proskauer Rose and Hodgson Russ. I also had the good fortune of becoming reacquainted with the judge when he was named the General Counsel for the South Florida Water Management District. For those of you who aren't familiar with the South Florida Water Management District, it has a budget that runs in the hundreds of millions, if not in excess of $1 billion a year, and is the state agency primarily responsible for Everglades restoration, which is the world's largest wetland restoration project. He certainly had a more than full-time job there before being named by Governor Scott in December of 2014 to the bench. So we have a very well-qualified person to serve as the moderator on the Federalism and Environmental Law panel. And with that, Your Honor.
Thank you. Thank you, Greg. I appreciate that introduction, that kind introduction. Good afternoon, everybody. This is our last panel, so I'm hoping that we'll keep everybody awake. It's after lunch. Hope you've had a chance to refill some coffee. We got hit by this panel also got affected by the blizzard, and originally we had it's still a very well-balanced panel, but we were trying to balance it out with representatives from EPA. We originally had Roger Martella, who was George W. Bush's General Counsel at EPA, as well as Avi Garbow, who is President Obama's current General Counsel at the EPA, at the Environmental Protection Agency. And unfortunately, Roger Martella was unable to come because of the storm. And Avi Garbow also was unable to come, although Avi is on the phone with us, so you can see that we have a little name tag for him there, but it's in front of the speakerphone. So we will do our best to hopefully be able to hear him. And we tried to get it by video conferencing, but evidently we did not have the capability to do that. So we have him by phone at least, and we really thank him for being able to participate. We know how busy he is, and the fact that he wasn't able to come down here because of the storm, but was willing to participate by phone, we really appreciate it. So we have Patrick Strawbridge, who I'll introduce in a few minutes, who is filling in for Roger Martella. And I have the pleasure of introducing Professor Erin Ryan from Florida State University, who's on our panel here today. Professor Ryan teaches environmental and natural resources law, property and land use, water law, negotiation, and federalism at Florida State University. She has presented widely in the United States, Europe, and Asia, including the 9th Circuit Judicial Conference, the National Association of Attorneys General, the United States Forest Service, and the United Nations Institute for Training and Research. She has advised National Sea Grant, multi-level governance studies involving the Chesapeake Bay, and consulted with multiple institutions on developing sustainability programs. She's the author of many scholarly works, including the book Federalism and the Tug of War Within, which I think she's going to tell us more about this afternoon, and we're looking forward to that. It's a very timely topic, and the fact that we're so fortunate to have somebody who's written such a scholarly book on the same topic, Federalism and Environmental Law, that this panel is about. She's written the book Federalism and the Tug of War, and we want to hear a lot more about that. And we're very grateful to you for being here and sharing those thoughts with us. Professor Ryan is a graduate of Harvard Law School, where she was an editor of the Harvard Law Review and a Hewlett Fellow at the Harvard Negotiation Research Project. She clerked for Judge James Browning of the U.S. Court of Appeals for the Ninth Circuit before practicing environmental land use and local government law in San Francisco. She began her academic career at the College of William and Mary in 2004, joined the faculty of the Northwestern School of Law at Lewis and Clark College in 2011, and joined Florida State University in 2015. Professor Ryan spent 2011 and 2012 as a Fulbright Scholar in China, during which she taught American law, studied Chinese governance, and lectured throughout the country. She also lectured at leading universities and government agencies in Japan, Vietnam, and India. As I said before, we're fortunate to have by telephone President Obama's General Counsel, Avi Garbow. On August 7, 2013, Avi Garbow was sworn in as General Counsel for the United States Environmental Protection Agency. During his tenure as EPA General Counsel, Avi has worked closely on President Obama's environmental team, including the Clean Power Plan, the Clean Water Rule, and other initiatives. Prior to his confirmation as General Counsel, Avi served as EPA's Deputy General Counsel with a primary focus on the agency's air and water programs. Avi also began his legal career at EPA, serving in EPA's Office of Enforcement and Compliance Assurance from 1992 to 1996. Avi then served with distinction as a federal prosecutor in the Department of Justice's Environmental Crime Section. In private practice, Avi was a litigation partner and junior partner at two major international firms. Avi has served on the board of directors of various environmental and international human rights organizations and has held leadership positions in the American Bar Association's International Human Rights Committee. He is the recipient of the University of Virginia's School of Law's Robert F. Kennedy Award for Public Service and holds a master's degree in marine affairs. Interesting fact, is a former volunteer firefighter. So hopefully he'll give us some firefighting tips today, as well as some of what he does at the very important Environmental Protection Agency. Patrick Strawbridge, who's filling in for Roger Martella, and we thank him for filling in on short notice for us, is a partner at Consovoy McCarthy Park. The Consovoy McCarthy firm practices in the area of appellate and litigation with offices in Washington, D.C., New York, and Boston. The firm is involved in a number of high-profile litigation matters at the Supreme Court and other federal courts, including the ongoing challenge to the EPA's Waters of the United States rulemaking, which you'll hear a lot about on this panel, because it's a very hot topic. It's one that I worked on when I was at the South Florida Water Management District, so it's something that I had to deal with and address in terms of how it was going to affect the state of Florida and our federalism concerns between the state of Florida and the federal government as to how we're going to properly balance out the regulatory scheme that was envisioned in our federalism structure here in Florida. Patrick previously served as a law clerk for the Supreme Court of Maine for Judge Morris Shepard Arnold on the 8th Circuit Court of Appeals and for Justice Clarence Thomas on the United States Supreme Court. Very impressive. Before joining Consovoy McCarthy, he worked for 6 years as an appellate lawyer at Bingham, McCutcheon, and Morgan Lewis. I have the pleasure of also introducing my good friend, Matt Leopold. Matt Leopold was General Counsel at the DEP, Department of Environmental Protection here in the state of Florida at the same time that I was General Counsel at the South Florida Water Management District, so we worked very closely on things like the Waters of the U.S. rule that EPA has, and he's a very good friend, an excellent attorney, and a very, very smart man, and I'm very, very pleased to have him on this panel. He's a lawyer with Carlton Fields in Tallahassee. He's the, as I said, the former general counsel of the Florida Department of Environmental Protection and he's a former attorney at the U.S. Department of Justice, the Environmental and Natural Resources Division of the United States Department of Justice. Matt Leopold has worked on some of the most complex and consequential environmental litigation in this country, including the Florida versus Georgia litigation before the U.S. Supreme Court to address Florida's conflict with Georgia's consumptive uses of water, the U.S. versus the BP Exploration and Production Inc., representing the U.S. to address the 2010 Deepwater Horizon oil spill in the Gulf of Mexico, and a case that I worked on with him, U.S. versus South Florida Water Management District, representing Florida in the 11th Circuit Court of Appeals in the long-running Everglades case brought by the United States to clean up the Everglades. He's led multiple actions related to oil and gas developments in the Southwest Florida. In addition to his work at the Department of Justice, as well as his work at the Department of Environmental Protection of Florida, he worked at the Washington, D.C. office of former Governor Jeb Bush as a federal policy advisor on environmental matters, representing the Florida DEP and Florida's 5 water management districts on issues that they faced in Congress and with other federal agencies. It's my pleasure to first call upon Professor Erin Ryan to share with us her thoughts on this panel. Professor?
Judge Artad, thank you for that very kind introduction. And Matt, thank you so much for the invitation to be here and to be part of this wonderful program. It's such a pleasure to be here and an honor to be part of an important conversation that we're going to be having about environmental federalism. My job on the panel is to frame the issues, to introduce the issue and frame the conversation that we're going to have. And I'm going to be doing it in part by drawing on some of my previously published work. I, in fact, just recently contributed the closing chapter to a book on environmental federalism that's coming out next month, The Law and Policy of Environmental Federalism. And I was asked there to tie together the various themes running throughout different substantive areas of environmental law that are federalism sensitive in light of my other book that the judge kindly mentioned, Federalism and the Tug of War Within, which is a general federalism theory book. It's not environmental in particular, and yet it is suffused with examples from environmental law, because there are so many. There are so many hot-button controversies in environmental law that invoke federalism. Increasingly, they are all over the law. But in many respects, it all began with environmental law. And so I wanted to answer the question, wanted to ask the question, what is it about environmental law that is so troublesome and contentious and difficult for federalism? And so in writing the closing chapter for the book, I thought there were 3 important questions to try to answer. And I'm going to try to touch on them today. The first question is, why is it? Why is it that environmental federalism is so contentious? And in fact, I'm going to make the claim that it is to some extent the canary in the coal mine of wider federalism controversy. Many of the other controversies we're now seeing in other areas of law, we've talked about at this gathering, in healthcare and education, are controversies that we saw first in the environmental context, sometimes not even realizing we were talking about environmental law. And I'll say more about that in a minute. I'm going to argue the reason environmental law is the canary in the coal mine has to do with 2 things. One of them is the nature of environmental problems themselves as being perhaps unique, and the other has to do with the nature of federalism more widely. So I'm going to get there shortly. I also think it's interesting to then take note of how environmental law and environmental governance has responded at the structural level to these challenges. In other words, how have programs of cooperative federalism in national environmental law and within states and partnerships between local and state levels of government, how have they responded to the kinds of the issues that give rise to federalism controversies? And we see that they have, with a series of almost methods of asymmetrically allocating authority along these different axes of scale. And as an observation of note, I think it's interesting to see how often they require some form of consultation and negotiation and competition and collaboration to try to get at some, if not consensus, at least some meeting point to move forward. And then the final question is, if that's true about environmental governance and we like it, then do these forms of governance that have evolved in environmental law, are they good models for other areas of governance? Are they bad models because we don't like the way that they have evolved in environmental law? Are other areas of law better models for here? So these are questions that I think are worth asking. Today, because I'm going to keep my remarks to fit within the panel, I'm going to focus primarily on question number 1, spend most of my time there, but I'd like to at least nod to question number 2 at the end and maybe save our conversation about question number 3 for Q&A. But let me jump right in and make my proposition: federalism, environmental federalism, as the canary in the coal mine for all federalism controversies. You may have noticed, or many of you did, maybe, that many of the court's most contentious federalism cases really are environmental cases. For example, New York v. United States, the case that ushered in the Rehnquist Court's new federalism jurisprudence and that gave us the anti-commandeering doctrine of the 10th Amendment, is an environmental case about low-level radioactive waste management. Hodel, another important 10th Amendment case, is an environmental case about mining. By the same token, many of the court's most contentious environmental cases are really federalism cases, even if we don't think about them that way at first blush. For example, the Rapanos and the solid waste agency cases that bring us to the clean water rule that we'll be talking about today are environmental cases about the reach of federal authority under the Clean Water Act. And while they're technically statutory interpretation cases, all of you who have read those cases know that they're really suffused with anxiety about the reach of federal power under the Commerce Clause. It's really a federalism issue just below the surface, and certainly those arguing the cases and the justices deciding them are well aware of that. Other environmental cases that are also important federalism cases recently, the EPA v. E.M. Homer case, even Massachusetts v. EPA, the case about whether the Clean Air Act must address greenhouse gases. Not seen as a federalism case widely, setting aside the standing issue, which was more overtly a federalism issue, still gets at some of the issues that define issues of federalism. Which level of government should be responsible for making these kinds of regulatory policies and decisions? And in that way, I think there's something to be said in common. So my argument in a nutshell: why is this the case? Why are so many federalism cases really environmental cases? Why are environmental cases really federalism cases? It has to do with the way that environmental law is prone to such extreme federalism controversy, not just average federalism controversy, but extreme. People are mad about it, making viral videos, ditch the rule on the web, really mad about federalism controversy, because environmental law is allocating power in regulatory contexts where both the state and the federal claims to authority are simultaneously at their strongest. That is to say, both the state and the federal government have really good arguments as to why they should be the one to have the final say. It has to do with the way environmental problems very often match the need to regulate some harmful use of a specific parcel of land, which we normally think of as kind of a local government activity to do, land use planning, with the need to regulate the boundary crossing harms that may be associated with that use. And regulating boundary crossing harms, especially if the boundary crosses a state line, is the kind of thing we normally think of as something the national government should do. So we have this hallowed understanding that governing land use is among the most sacred of local prerogatives, and that's important. But the regulation of harmful externalities is among the original predicates for national authority, and that's implicated too. And so to some extent, environmental law is so hard because everyone is so right in the argument about why their chosen level of government should be the one to decide. Now you might say, how is that really different from other areas of law, where there's some kind of a conflict between the police power that the state wields, that has always been there, and perhaps federal power as enumerated in the federal government, maybe they came later. We see the same kinds of conflicts in criminal law, and in health law, and education law, and family law. So is this really any different from those areas of law? And to some extent the answer is no, and so we are now seeing federalism controversies in all of these other areas of law too. But it came first, by and large, in the environmental context, and I think the reason has to do with this. The connection of environmental law to land use, and land use policy, and land. And I think you can kind of see from the pictures I'm showing you here in my slide, but the problem is land is really different. Land, I will even take the proposition, land is so if we are trying to tailor regulation appropriately to the context, land is more different than people. Now, people are also really different. Let's acknowledge that. Communities are unique. There are all sorts of identifying unique features that make it reasonable to think about narrowly tailoring other areas of law with regard to people. But even though people are different, land is more different. And so even though we confront local differences and preferences in other areas of law, we nevertheless have fairly widespread consensus on what constitutes health, or theft, or math. And while state law may differ at the margins in regulating these different areas of law, they really only differ at the margins. Whereas environmental management differs pretty radically between and even within states because of the way that land is so locally used. So the answer to the question of what do we need to do to properly control for harm is going to be different from one place to the other. Think about what it takes to manage water pollution in the state of Oregon, where I recently moved from, and now think about what it would take to manage water pollution in Arizona, or Iowa, or New York, or Florida. And I probably don't need to convince you that it's going to require wholly different sets of expertise. But just in case I do, here's what they are. Here's what we need to know to think about how to regulate water pollution. You need to know the contours of the land, the elevation, the precipitation, the seasonal weather patterns, prevailing winds, watersheds, soil quality, habitat, population density, zoning laws, cultural uses, local economies, where the local industry is operating at any given moment in time, where the stressors are. And the thing is, you also have to be there to watch as they change, because all of those things are going to change. And that doesn't mean that the federal government can't have someone there watching to pay attention. That's what regional administration is. That's what Region 4 is doing when they have federal representatives locally. But it does mean that the answer to the question of what do we have to do to get this right will change pretty radically from one place to another. And if we get it wrong, it can be really costly to the communities that are impacted. Bad decisions made about this without the benefit of local expertise, as you know, can portend serious environmental, cultural, and economic harm. If things go wrong, damage to soil, water, and other local resources can have huge collateral consequences for communities, and that's the case for local decision-making. But here's the thing. If one community fails to prevent spillover harms to the neighboring community, the consequences are just as bad, just as dire. And so that's the case for larger scale decision-making. And that's why environmental law is so troubling. Environmental law is not alone in this respect, but it kind of fits into this realm that I'm discussing in the Federalism and Environmental Law within book, which I'm calling the interjurisdictional gray area. And really, I'm talking about areas of jurisdictional overlap where both the state and the federal government have legitimate interests or obligations that give them cause or a good cause for regulating. And the problem is, how does federalism allocate authority in those zones of jurisdictional overlap? The federalism issue is always who should get to decide, who's going to have the final say when there's some kind of a conflict. And of course, the Constitution gives us some guidance to work with. There is the enumerated powers, there is the 10th Amendment, there is the Supremacy Clause, and some of our questions are answered that way. And nevertheless, we still see two main areas of uncertainty in environmental realms and other realms of jurisdictional overlap. And it has to do with when there is these competing claims for jurisdiction. Are we going to resolve that uncertainty by trying to draw a boundary line down the middle and clearly allocating these powers are going to be exercised at the local and state level, these powers at the federal level? And it's kind of what we do maybe with immigration is a good example. The wetlands issue under the Clean Water Act has been historically an example where we try to delegate from here on, it's your responsibility, from here on, it's yours. But in environmental law, more often than not, in some of these other areas too, we increasingly tolerate simultaneous regulation on grounds that both sides have legitimate interest in doing so. So criminal law being an example. And environmental law too, we often manage it by having a system of floor preemption, where the federal government will regulate and say, you can't be less stringent with the concerns we have than this, but beyond that, you can do whatever you want. And so they're simultaneously regulating. Nevertheless, the question is, when there's really a conflict, who has the trump card? When should the federal government preempt? When should the federal government defer, even if the federal government has the authority to preempt? And increasingly, the more interesting question, I think, in environmental law is not whether the federal government could preempt, certainly the way that the jurisprudence has pointed over some period of time, has given the federal government a lot of tools under the Supremacy Clause. But the more interesting question is, when should the government preempt, the federal government preempt? Even if it could, when should it not? When should it defer? And it turns out the federal government all the time realizes that it shouldn't preempt, because the states and the local governments have such critical perspectives and tools and expertise to draw on that they really can't replicate. And I think that is a feature of environmental law that we need to talk to. Now I'm going to shift to widen the conversation. I've discussed why I think there are features unique about environmental law that make it prone to federalism controversy. Now I'm going to talk about why federalism in general. What is it about the nature of federalism in general that also leads to conflict in environmental law? And to have this little conversation, I want to persuade you of this. I want to persuade you that the best way to understand federalism is not just that it's a contest between state and federal reach. We often see it played out that way, that's for sure. But I don't think it's the best way to understand it, nor do I say the best way to understand it is as a contest between judicial and legislative interpretive supremacy, although if you read the literature, it would seem like that's it, because that's all we have to talk about. Nor is it best to see it as just a contest between original intent and living constitutionalism. All of these things may be true. But what I want to convince you of, with more time, maybe I will, the best way to understand federalism is that federalism is a strategy for accomplishing good governance based on a clear set of values. A set of values that we turn to federalism to help us actualize in government. That's really what federalism is about. And these values, you'll recognize them. Here are the core values that tracing hundreds of years of the literature and the jurisprudence reveals. We like federalism because it helps us get checks and balances in government between local and national authority that protects against government overreaching or abdication on either side of the line. We want federalism to help us manage accountability and transparency in governance to enable meaningful democratic participation on all points of the jurisdictional spectrum. We want federalism to protect and foster local diversity and innovation and competition, creating space for the great laboratory of ideas that we all love about federalism. We also want federalism to demarcate some clear national authority to deal with spillover problems and resolve collective action problems that the states, for example, were not able to handle under the Articles of Confederation, and to vindicate core constitutional promises, as in the first and perhaps second and the other amendments in the Bill of Rights. Finally, and most overlooked, I think we also want federalism for the way it enables us to harness interjurisdictional synergy that arises between the kind of governing capacity that develops and works best at the local level, and the kind that works best at a national level, to get at different parts of interjurisdictional problems that neither side can really meaningfully resolve without the other, because of the nature of interjurisdictional problems. Now here's the thing, and now I'm drawing from the book. These values that I've described, they're all great values, right? Everybody loves those values. Nobody's against those values. We want them. That's what we want federalism for. The problem with federalism, the problem for federalism, is that these values are suspended in a web of tension with one another that makes it very difficult to satisfy all of them all at the same time. Here, I'll go back to that previous slide for a moment. Some of this is obvious, right? There's tension between localism and nationalism. We've already talked about that. But some of these tensions are less obvious and just as important. For example, take checks and balances, take accountability. If all we really cared about was accountability in government, federalism, kind of a bad idea, right? Because if you want to know which bums to throw out if things aren't going well, federalism gives you two levels to try to keep track of. If you really want to know which bumps to throw out, much more efficient to just have one level of government, a fully national system like France or China. And we've made it more confusing. Why? Because we really want those checks and balances. Of course, if we only cared about checks and balances, we could ditch the Supremacy Clause and just have the two sides duke it out on the force of their own good ideas. We don't do that because we kind of want national authority to deal with collective action problems like interstate commerce. And so I could go on. I could convince you more. There's all this tension. And so the problem for federalism is, how do we figure out how to resolve them? And the truth is, and my thesis in the book is that the Constitution mandates, but incompletely describes our system of dual sovereignty in this respect that really requires some exogenous theory of federalism that a decision maker is applying in order to fill in the blanks when our relatively vague constitutional federalism directives are applied to actual cases and controversies. And because there needs to be some theory that helps us know why we're going to privilege checks here, why we're going to privilege accountability here, we see the Supreme Court wildly vacillating over time in its federalism jurisprudence. And you all know this, the Supreme Court has experimented with dual federalism and cooperative federalism, and over the years gone back and forth in some really dramatic ways, and that's its effort to try to resolve these tensions. So let me bring this back now to environmental law, and I'll kind of close with these observations. The environmental federalism conundrum is that somebody has to decide. At the end of the day, someone's going to make a decision about which values to privilege over others. And this is true in all areas of law, but in many other areas we do better at finding some consensus point. There are reasons to think that even, military should be managed locally, but we've come to something of a consensus. No, we're going to do that nationally. With environmental issues, we almost never do. It's very rare to get to that consensus because the tension between these values are so profound in the environmental context, not just localism and nationalism, but in all these other areas. And so in the book chapter that I'm drawing on, I trace in different Supreme Court opinions how different justices have wrestled with these values, even within similar ideological groups, coming to different conclusions. Energy law is a really excellent example of a substantive area right now where we can see these values in conflict. It's especially interesting because here the conflict isn't just between the state and the federal government, it's often between the local government and the state. And they're really very similar issues operating, and we see different states going in different directions, where Pennsylvania has decided to empower local decision-making even at the expense of state law, whereas Colorado has decided to preempt local decision-making in order to protect state law, and so the debate continues. Now, I'm not going to talk about this, I'll just say if we went further and we looked at the different forms of cooperative federalism, I think we'd see these interesting models of government. I'm not going to talk about this. In fact, I think I'm not going to talk about it at all. I think I'm going to close to protect time for my co-panelists, except to say this. We often talk about federalism like it's a zero-sum game. It's a zero-sum game. It's either going to be the state or the federal government is going to make a decision at the expense of the other, and I think it isn't. And I think our job is to try to find ways, and environmental law does this in some ways well, in other ways less well, of trying to find ways of bringing in consultation and collaboration and competition in order to find those opportunities to enhance the interests and the strengths of local and national regulatory authorities simultaneously, rather than always seeing it as a zero-sum game. So I close with that observation and look forward to my co-panelists' contributions. Thank you.
Thank you, Professor. Avi, are you on the phone?
Yes, I am. Can y'all hear me?
Yes. Okay, we have a microphone up to the speakerphone, so I think everybody can hear you. Please give us your comments, and thank you for participating.
Good. Well, thanks so much. And again, I'll kind of rely, Judge, on you and others to let me know if the volume is too loud or not enough. But I do appreciate the opportunity to speak with y'all by phone. As Matt alluded to, I'm looking out at a blizzard at the moment. We've got my 25th hour of snow and 2+ feet. So I thought I was going to trade this for some time in Florida, but it was not to be. But I really do appreciate the accommodation and the chance to at least visit with you all by phone. It might strike you as not too odd to say that this is not a typical audience for me. But I think because of the invitation to talk to the Federalist Society, and certainly the Florida chapter, it was one that I was especially eager to take advantage of. My hope had been, of course, to visit with you all, to spend as much time as I could kind of listening to you and hearing your concerns. So at the very least, my hope is that this is just the beginning of the dialogue, both with your Florida chapter and elsewhere in other chapters around the country. My sense of things as well is that we've got, I think in this arena, many shared interests. And that really is to make sure that the federal government, certainly an agency like the one I work at, the Environmental Protection Agency, faithfully implements our nation's environmental laws for the protection of human health and the environment. So when you think about one of the steadfast principles of the Federalist Society, that being rule of law, that is at the foremost of my own attention in the role that I play at EPA. When we start to talk about certainly federalism and environmental laws, I want to start by just talking about the tremendous success of our nation's environmental laws. We're entering, I think as folks probably know, about the 5th decade of major environmental laws in our country. This was mine was an agency established by President Nixon. If you look at the statutes that we primarily administer at EPA, nearly every one of them was passed by a huge bipartisan majority of Congress. I think, and it's worth checking this, that probably the majority of the laws we administer, at least the major ones, were probably signed into law by Republican presidents. So again, it's a body of law that has developed over decades, been implemented on Democratic administrations, Republican administrations, with tremendous success. And it's one also that I think is tremendously important. I go around and talk to various groups, certainly the groups that are not themselves focused on environmental law. And you think about areas of law that have the widest breadth, if you will, of consumers and beneficiaries, and there really is none that surpasses, I think, environmental statutes. Everybody, every one of us, of course, consumes air, water, and needs kind of safe communities and healthy lands, really to survive and to prosper. And so we're all direct beneficiaries of these laws. And our system of environmental protection, which is also, by the way, I think one of the very few areas of law that were truly born and developed in the United States, not elsewhere around the world, binds EPA and the federal government and the states together in a tremendous way. It makes us partners. It makes us reliant on one another. And that, for me at least, in my experience, is the nature of cooperative federalism. It's why we have been so successful in this country, because of that relationship coming out of the architecture of the statutes between states and the federal government. By and large, it's a system that gives states flexibility, but also the responsibility to assure that minimum standards of protection are met. And so it is truly one of those areas of law that works best when we work together. And I think, notwithstanding kind of an obvious focus on some of the cases, the litigation that's ongoing, and we can talk about that as the conversation develops. But we have seen tremendous successes with that state-federal partnership. I start by thinking about the degree of public participation that is demanded by our laws, and certainly that EPA benefits. And as folks know, as a regulatory agency, most of the actions taken by my agency, EPA, are governed by the Administrative Procedures Act. And public participation is really at the heart of that. Virtually everything that we do when it comes to the legal analysis that goes into it, the scientific and technical bases that go into our actions, everything is made stronger, in my judgment, by the public's participation in our rulemakings. And by this, I don't just mean the couple-inch thick comments that are drawn up by the lawyers and that the agency routinely gets. All very important and critical, but the degree of public participation, and certainly the wider it is, I think, correlates to the strength of the agency's outputs and its rulemaking. And states are critical, really, in all phases of what we do. We work extraordinarily well. We pay a great degree, appropriately so, of attention to our co-regulators at the state offices. Our headquarters offices at EPA, and I would note especially our regional offices, are in constant touch with our state counterparts. I know certainly Matt and perhaps Judge Artow, just from their roles in state government, hopefully are aware of that, would concur. But we're constantly working with the state on matters that impact the air, water, waste, pesticides, etc. On everything from rule development, from rollout, implementation, and enforcement. And indeed, most of that work, and they would know best, is done at the states. The structure of our statutes really puts the laboring oar for most of what gets done in the environmental field on the states and at local levels, where I think it can be most effective. I would say that also on the legal front, every one of those state environmental commissions and myself and my colleagues. We've got quarterly calls and meetings, really for the first time, I think, knitting together state and federal, both regulators and lawyers, and I underscore lawyers here, whose clients have already been working together. I have also focused a great degree of attention and outreach to the Attorney General community. It was about, indeed, a year or so ago, I found myself down in Florida at the National Association of Attorney Generals meeting, visiting with a number of state AGs, and in particular took advantage of introducing the cadre of recently elected attorneys general to the legal resources of EPA and our shared interests. So it continues to be an ongoing focus of how we at the agency can reach out and strengthen those connections with our co-regulators at the state. We've also had, I think, a large number of successes in the realm of cooperative federalism in Florida. Just in my time back at the agency, in the last 6 or so years, I have had the privilege of working certainly with, I imagine, some of the folks in the room there on matters like Florida Everglades, on matters like the numeric nutrient criteria. And as is so often the case, we dealt with this in the midst of litigation. In both cases, I should say, where the agency was in part the defendant here. When it comes to the Everglades, which is certainly a national treasure, but an economic and environmental jewel of the state of Florida, we were dealing with a lawsuit filed over a decade ago by the Miccosukee tribe and the Friends of the Everglades, dealing with revisions to water quality standards. And I don't need to go into too much detail about the history of that, and I began to suspect that many folks in the room lived it both professionally and personally. But we found ourselves, and I certainly found myself at EPA in the Office of General Counsel, facing a contempt motion for failing to abide by the district court's ruling in 2008, which required us to invalidate the water quality standards set by the state for discharges into the Everglades. And we had a very delicate back and forth between the agency, EPA, the state of Florida, Florida DEP. I worked extraordinarily closely with Herschel Vineyard, the former head of FDEP, and the general counsel of FDEP, I think Matt's predecessor, in a very successful way, all with the goal of putting Florida back in the driver's seat, of getting the state back in its rightful position to issue water quality standards that follow the science and comply with the law. And I think we've got an extraordinarily kind of cost-effective and collaborative solution that put back the state's important leadership role and kind of left us with a state-led solution to restoring the Everglades. Similarly, with the numeric nutrient criteria, once again embroiled in litigation there, and we had, I would say, a multi-year back and forth between state proposed rulemakings and federal proposed rulemakings. But the net result of that dance, if you will, was both to comply with the law and to ensure, as best we could, that the state had the lead in issuing water quality standards that were provable under the law. So I think it is yet another example of a successful partnership and the efforts that both the state of Florida in that instance and the federal government at EPA made to ensure that the cooperative federalism structure of the Clean Water Act in particular worked both for the state and EPA, but also for the people of Florida. Now, I want to just end with one comment, which is we're going to talk a lot about cooperative federalism, and I've already kind of laid out as a predicate that that partnership is really the reason for so much of our environmental success. But I want to make the point that that architecture, that structure, and that partnership cannot substitute for the ultimate goal. And the ultimate goal of these statutes that we all live under is to make sure that the citizens of every state and every community get the full measure of environmental and health protections that those laws will have to afford. And at the end of the day, it is a shared responsibility but we cannot, and I emphasize that both for EPA and certainly for the states, sacrifice that responsibility by what I'll call blind fidelity to the virtues of partnership. Our responsibilities ultimately lie in the first instance to the law and to the people. And so there are going to be times when there's federal-state tension. I think it's natural. There's going to be times when there is disagreement, and certainly there will be times when there is litigation. I don't consider any of those to be necessarily harbingers of failure. On the other hand, or I should say, of signs that our environmental laws are not working. The fact of the matter is those lawsuits, those tensions, those disagreements are vastly fewer than the less heralded successes that mark our everyday work together, that don't get the press, that don't get the publicity. But again, the career folks in my office who have multi-year relationships with the career folks at FDEP and in state offices around the country are working on a daily basis to make sure that this partnership and this cooperative federalism environmental laws work. And while it doesn't necessarily get the press of the tensions and the cases and the disagreements, I think it is something to applaud and so to recognize. So I want to end by just saying there's always room for improvement. In my limited time at the agency, I'm going to continue to both emphasize the need to partner with states and localities, the need to make sure that the balance of power, again, works under the law for the people. And I can kind of commit to you, as I have committed certainly within the ranks of EPA, to make every effort we can to work closely, cooperatively, and successfully with our state partners. So let me end there. Again, thank you. I know it's a little bit unusual to have a speaker just participate by phone, but I do appreciate it and look very much forward to the further comments and whatever dialogue. Thanks again.
Okay. Thank you, Avi. I'll turn it over to Patrick now.
Thank you. And I suppose my designated role in this panel as a litigator and someone who's currently involved in litigation against the EPA is to highlight the disagreement and tension that Avi was just referring to. So I'm happy to do that and to wear that hat. It is no doubt true that there are countless numbers of situations where the cooperative federalism structure of the environmental statutes has yielded a lot of beneficial results, and a lot of those are not heralded or talked about in the press. But let's talk about one of the situations where the tension has sort of arisen and is very much of interest in a lot of people. And so the Waters of the United States rule is actually something that's sort of been in flux for a long period of time. It stems from immediately from the authority under the Clean Water Act, which was passed in 1972. The stated objective of the act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. I do think that it's useful to kind of pause, especially when we're at a Federalist Society event, to recall that at its essence, under our structure of government, under the powers of the Constitution, which are generally reserved to the states, except where specifically enumerated for the federal government, what Avi runs is actually the Department of Commerce. Because the federal authority to regulate the environment arises from the Commerce Clause. However, that has been interpreted, and certainly that's a question that remains in flux, and I think will continue to remain in flux, and overshadows, among other things, the questions to the proper limits of the waters of the United States. The Clean Water Act does give federal agencies regulatory authority over certain waters in this country. It's actually given authority over navigable waters, but the navigable waters themselves are defined to include the waters of the United States. In the 80s, the agencies promulgated a rule that defined the waters of the United States to consist of waters used in interstate commerce and waters affecting the use of interstate commerce, which could include interstate lakes, rivers, streams, impoundments, tributaries, the territorial sea, and wetlands. Obviously, most people would agree that the waters of the United States include things like jurisdictional boundaries between states, navigable rivers, the Mississippi River, channels of commerce, for example. I don't think that there's much disagreement that federal authority runs to that. The Supreme Court has had the occasion, I think, 3 times to expound upon what are sort of the limits of the waters of the United States. The first opportunity was in 1985 in a case called Riverside Bayview Homes, in which the court determined whether or not a Michigan wetland constituted a water of the United States. The court concluded that the Army Corps of Engineers, in fact, did have jurisdiction because the property in question was part of a wetland that actually abutted onto a navigable waterway. So it was touching a navigable waterway. The effects of the wetland extended beyond the boundary of the specific property at issue and actually intersected with the navigable waterway. So the Supreme Court had little problem in determining that constituted waters of the United States. In the 2 other cases, the Supreme Court has expressed more of a limited view, and some of them was referred to by Professor Ryan already. In the Solid Waste Agency of Northern Cook County case, which I will call SWANC, the court determined that the Clean Water Act did not give the Army Corps of Engineers jurisdiction to regulate an abandoned sand and gravel pit in northern Illinois that was a habitat for migratory birds. It was a non-navigable, isolated, intrastate water, and as such could not be determined to be waters of the United States, at least as currently interpreted by the court in that case. In raising the limits of the Clean Water Act's authority, the court emphasized the constitutional concerns that were really underlying it, because they're essentially, I think, Professor Ryan and I were talking about this before, I think she'll agree. In this context, they're really kind of one and the same. I mean, what we're talking about really goes to whether the federal government has authority at all. And so when we define the waters of the United States and the terms that the statute uses, there's theoretical daylight between that and the limits of constitutional power, but certainly I think, my clients and a number of states would determine that with this latest rulemaking, we're pushing right up against whatever the most expansive limits of federal authority are with the current definition. The last case, and it was already referred to today as the Rapanos case from 2006. In that case, it was the court's assertion of jurisdiction over Michigan wetlands that were near ditches or man-made drains, which themselves eventually emptied into traditional navigable waters. The Rapanos decision actually comes with the added bonus of kind of a split. There's not a clear majority decision. There's a plurality with a concurrence in judgment from Justice Kennedy writing for himself. The plurality in that case held that the waters of the United States does not include channels through which water flows intermittently or ephemerally, or channels that periodically provide drainage to rainfall. In other words, it was really focused on the continuous nature of the flow into a navigable water. Justice Kennedy, I think most people view as provided a more flexible analysis, and I think Professor Ryan has some interesting comments to say about what the difference is between his approach and that of Justice Stevens, which we upheld the rule. His view was a significant nexus was sufficient as long as water, quote, could significantly affect the chemical, physical, and biological integrity of waters that were more readily understood to be navigable. And I will note that of some import in the current litigation is the fact that, as written, at least the opinion says, its waters are going to significantly affect the chemical, physical, and biological integrity of those waters, because the current rule actually uses an or instead of an and. So there's some question as to how consistent it is, at least with the Rapanos concurrence. Following Rapanos, there was basically some guidance issued as to how the CWA was going to be interpreted. It ultimately led to a long anticipated rulemaking process, which culminated on June 29th. I'm going to obviously skip over a lot of that process here. We could spend the full hour and a half of this panel talking about the specifics of the rule and its enactment, but I am confident that would not make this any more the happiest place on earth. So spare all of us that. The extent to which the final rule kind of broadens the previously understood definition of the waters of the United States. And so I'll give some examples here. The litigation goes into greater detail, and certainly we'll all be grappling with it. But among the changes that are significant is that the new rule adds a category of waters, not only waters that are adjacent to kind of primary navigable waters, but it also includes neighboring waters that are within certain distances, including, say, 100 feet of the high water mark or within a 100-year floodplain. That's a significant portion of, especially a flat state like Florida, in which case, and I don't know if Matt or others in the audience can probably testify just how much of the land mass falls within the floodplain or within 100 feet of the floodplain. But it's a significant amount. There's also a new category of tributaries, or tributaries, I should say, are defined in a way that expands federal jurisdiction over any stream, including a stream that is dry for a large percentage of the year, as long as at some point it contributes flow to a navigable waterway, and it has some kind of physical indicator, which we call the banks and the bed and the banks. It has to have, in fact, it has to have certain physical characteristics, which is defined as a bed or a bank, and a determinable ordinary high water mark. Thank you very much. You might think that a physical indicator actually means a physical indicator, but the rulemaking actually permits physical indicators to be determined at a desktop computer by applying some basic, environmental mapping or other features. So it does not actually require the observation of a bed or a bank in the field. It simply requires, a reasonable calculation that a bed or a bank or near water mark would be determined. The scope of the rule is significant. Certainly, some complaints in this case allege that we are more than doubling the amount of water that has previously been considered to be waters of the United States. The economic impact with respect to the permitting implications, even by the EPA's own estimates, run into at least the tens of millions of dollars annually. This is obviously a big deal, and as a number of states expressed concerns during the proposed rulemaking notice and comment period, and upon the announcement of the final rule, a total of 30 states have filed suit, either through their attorney general or through their local environmental regulatory body, seeking to enjoin the enactment of the rule. The final rule was proposed on June 29th, was to go into effect in August. There were suits filed in a number of district courts. At the same time, they were also filed in federal appellate courts. Those were so-called protective petitions. There is a dispute in this case as to whether or not the rulemaking is subject to challenge in the district court or under the authority of the federal appeals courts. That has to do with whether or not the rulemaking is equivalent or akin to a permitting process, or if it's just something broader and more definitional. That question is currently being litigated in the Sixth Circuit, and I'll talk a little bit about kind of where the litigation stands. But there were a number of suits filed. Florida joined one of the suits. Florida, I believe, joined the action in Georgia with a number of other states. And there was a large action that was filed in North Dakota involving a number of states. And the North Dakota one has some significance because there was actually, the district court reached the question of a preliminary injunction in that case, and in fact, enjoined the rule, issued a preliminary injunction against the rule on a couple of different grounds. The injunction noted that the challengers had at least stated a fair claim for a likelihood of success on the merits, and among the flaws that relied upon in determining that there was a good chance for proving that the rule could not be enforced was some of the boundary lines that we were discussing, within certain distance of a floodplain or within certain distance of a navigable water, were added late in the process after the initial comment period. And there is some concern that those numbers are arbitrary, or at least they're not supported by science. There was not an opportunity to provide comment on why is it 1,000 feet here or 4,000 feet there. Why is that the boundary by which we're determining whether something falls within the waters of the United States or not? Now, in fairness, and I was talking about here. The boundaries do have one virtue, which is that they provide certainty to the interpretation. At least if it's 1,000 feet or 4,000 feet, you can measure that, and you can at least know, well, perhaps maybe I'm falling within the rule. But on the other hand, the courts, the North Dakota court and the Sixth Circuit also, in a state application, said it's not clear that there was sufficient notice and comment on those boundaries, that there's a significant scientific basis in the record to support that. So that's one concern. But the larger concern, and the one that's maybe more interesting for everybody here, it goes to sort of the constitutional and statutory limits of what can be the waters of the United States. And both the District Court in North Dakota and the Sixth Circuit have indicated that at a minimum it is far from clear that the EPA's rulemaking is consistent with either Justice Kennedy's concurrence or the plurality opinion, and the limits that the courts at least appear to read in those decisions with respect to what can constitute the waters of the United States, whether or not it's reaching out more broadly and getting into ditches, puddles, ephemeral streams, the types of sort of passing.
It says no puddles.
There is a puddle exclusion. We'll talk about it.
And swimming pools.
And swimming pools.
Yeah, which gives us a lot of comfort.
Sorry. No, one of the concerns, there are exclusions, and I'm sure that Avi would be happy to talk about them, and by all means he should. There have been exclusions that are attempted by the EPA to address some of these concerns and to provide certainty. The counter-argument to that is that historically the EPA's application of its exclusions have been narrow, and they have not always been predictable, and they, in and of themselves, it's not clear exactly what these exclusions are going to extend to and how they will be applied. Back to the process. Some of the district courts that heard these cases, including the one in Georgia, determined that the district courts did not have jurisdiction. The jurisdiction was properly in the appellate courts. The district court in North Dakota obviously decided they did have jurisdiction. The jurisdiction was not the appellate courts. There was a move by the federal government to consolidate all these cases in multi-district litigation, the cases within the district court. That was rejected by the JPML, and so the district court cases were not consolidated. In the meantime, all of the various protective petitions filed in the courts of appeals have been consolidated in the Sixth Circuit. There was an argument in the Sixth Circuit in December on the question as to whether or not jurisdiction to challenge these rulemakings belongs in the district court or in the appellate courts, and we are awaiting a decision. However, as I mentioned earlier, the Sixth Circuit did issue a stay of the rule pending its decision, and in doing so, noted that there was a fair likelihood, a fair possibility that the challengers would be able to demonstrate a likelihood of success, citing some of the same provisions that I just described. And certainly, the court's ruling in that case is all of 2 pages long. It's in the context of a stay motion, but it does lay the groundwork, I think, for the notion that whatever court, whether it's the district court or the Sixth Circuit, gets around to doing this, the challenges are real. This litigation is likely to, I think, remain needed in whatever venue it is. And I think everybody has the expectation that at the end of the day that there's a very good chance that this case is going to be going back up to the United States Supreme Court, and it's going to be the sequel to Rapanos. So we'll be happy to talk a little bit more about that. I don't want to take up any more time. I want to give Matt a chance. He's got some experience with Florida's attempt to account for this rulemaking, and he's also going to talk about federalism and some other aspects. So I'll let him do that.
Thank you, Patrick. Okay, last but not least, Matt.
All right. Thank you. I want to thank my co-panelists for pulling this together in spite of the storm. And I want to especially thank Avi for appearing telephonically. I know it's a bit awkward, but I appreciate you being willing to be a good sport. Avi, since we are at Disney World, I wanted to let you know there has been intense speculation in the state of Florida of whether the moat around Cinderella's castle is waters of the United States. And if you could clear that up for us, we'd really appreciate it. In all seriousness, it has
a written legal opinion on that.
But, as the last speaker in the last panel of the day, and in a shameless attempt to keep your attention, I've decided to tell my best environmental joke. And as a young staffer to Governor Bush, desperately trying to impress some high-ranking officials at the Interior Department, I told this joke and killed, so you know, here it goes. A father and a son were lost in the woods, and they'd been there many days, and they finally they thought they weren't going to make it. They were starving to death, and just at the moment when they thought they couldn't go on, a bald eagle landed right in front of them. The father pounced on the bald eagle, killed it, plucked the feathers off, was able to start a fire, cooked it, and was eating it. And as about that time, a park ranger walked up and found that the father and the son eating the bald eagle feathers everywhere. And the park ranger said, "Well, we're so happy to find you, but we're going to have to take you in because killing a bald eagle is a federal crime." And the father said, "Please, we were desperate." And he said, "Tell it to the judge." So they went before the judge, and they pled their case. The judge said, "Well, sir, under the circumstances, I'm going to let you off this time." And he said, "Thank you, judge." And as they were walking out of the courtroom, the judge said, "Wait 1 minute. I have one question for you. I've always wanted to know, what does a bald eagle taste like?" And the father turned around and he said, "Well, it's kind of a cross between a whooping crane and a spotted owl." In any event, I would describe my career. I've been on the ragged edge of environmental federalism. I really have. And I've had the great privilege of working for the DOJ, as Avi did in the Environmental Division. And then got recruited to come here to Florida and be the General Counsel of the DEP, as you've heard. And so that really shaped my perspective, and I think I have a unique one, having both been in the federal system and the state system at working on these issues. It has changed my perspective on whether we need a one-size-fits-all national standard on some of these issues. But my conclusion, as the professor eloquently stated and Avi has stated, federalism is very alive and well in the environmental context, and it continues on because mainly the Congress had the good sense to put into these laws the principles of federalism, and not just constitutionally, which exists over all our national government, but actually in the statutes themselves. But the Congress, when the laws were enacted in the 1970s, and as Avi pointed out, mostly signed by Richard Nixon, the crises, there were environmental crises going on, legitimately. You may have heard the Cuyahoga River in Ohio was on fire before the Clean Water Act amendments of 1972. You may have heard, I'm sure everyone knows the LA smog crisis that existed in the 50s and 60s, and similar to what is happening in Beijing, China now, before we enacted our Clean Air Act. Since we're in Florida, we had the Cross-Florida Barge Canal, which some of you may know, which was supposed to connect the Atlantic and the Gulf of Mexico, going right through the heart of Central Florida and dredging and damaging many of our aquifers right in the heart of the middle of the state, which prompted President Nixon to sign the National Environmental Policy Act, which forced federal projects to look at environmental impacts before they occurred. But my premise here today is we're not at the level of crisis that we were. The environmental laws have been very successful, and they have been implemented in a bipartisan way and collaboratively. Just to make my point about the laws themselves, I wanted to read you briefly the introduction to the Clean Water Act. It says, "It is the policy of the Congress to recognize, preserve, and protect the primary responsibilities and rights of states to prevent, reduce, and eliminate pollution, to plan the development and use of land and water resources." So it's institutionalized in the Clean Water Act, and it's in other laws like the Clean Air Act as well, and our waste management laws. So the problem today that I see us facing, and having been on the state side in a state like Florida, which is doing so much to address our local environmental issues, is the federal government's expanding regulatory reach, and it's crowding out the proper role for the state governments to do what they do best. And I'm not arguing that we shouldn't have robust environmental laws to protect air, water, and lands. Just the opposite. And in fact, these complex areas require Congress to delegate much of their authority to expert agencies like the EPA, who are able to deal with technical matters that the Congress neither has the time nor the capacity to deal with. But the issue is Congress has given away too much of that authority. And in the Misretta case in 1989, the U.S. Supreme Court basically enacted under the non-delegation doctrine something called the intelligible principle. Simply that in order for the Congress to delegate authority to a federal agency, they simply must have an intelligible principle to work with in the statute. And federal agencies have taken that, and it's a broad grant of authority, and they've created all kinds of regulatory frameworks that I believe are, some of which are getting to the point of being unchecked. Just to prove my point, I wanted to quote a few stats. And generally, between 1993 and 2014, the federal agencies have issued 90,836 final rules. That's about 3,500 per year, or 9 each day. And in 2014, the Congress passed 224 new laws, while agencies imposed 3,554 new rules. That's a ratio of 16 to 1 between the federal agencies and the Congress. And to date, the Obama administration has finalized nearly 2,500 rules at a cost of nearly $670 billion per year. 670 billion, which is rough over a 10-year period, comes out to about 100 billion per year that the Obama administration has imposed. So the question is not whether we're cooperating, because I absolutely agree. Avi was a fantastic partner at EPA to the Florida DEP, and his worked with many of his colleagues, and very successfully in a partnership to restore the Everglades in particular, and that's going famously. But the question is, where is the space that the states are supposed to occupy, and is the federal government stepping too far into that space? We've talked a lot about the Clean Water Act and the rulemaking on the waters of the United States, but we haven't touched on the other big regulatory initiative that EPA is undertaking, the Clean Power Plan, which is the President's greenhouse gas regulatory initiative. By EPA's own estimate, the Clean Power Plan is going to cost implementation of $7 to $8 billion per year. To put that into perspective, my understanding, and I'll let Avi correct me if I'm wrong, but all clean air rules existing right now on the books cost about $7 billion per year to implement. So this would double the cost of Clean Air Act regulation in one rule. And of course, there's disputes as well in the litigation over the cost of the rule, and then the coal industry, which I recognize they may be a biased source, but they're estimating between $41 billion or $73 billion per year to implement the Clean Power Plan. And the thing is, what I've seen here in the state is that those costs are going to be passed on not to the utilities themselves. The utilities are going to be able to thrive, and they're going to be able to build new generation. It's going to be passed on to consumers, and so it's really a consumer issue with those kind of costs being implemented by the Clean Power Plan, whatever they end up being. And the other thing, the Clean Power Plan is incredibly transformative of our energy economy. If you've read anything about it, you may know that there's a dispute about the scope of the Clean Power Plan and whether EPA is within its lawful authority to issue a 2,000-page regulation based on essentially 2 paragraphs of text in the Clean Air Act known as 111D. So I'm reminded of what Justice Scalia said in the Whitman trucking case of 2001, and he said very famously, and it's going to be used in the litigation, that Congress does not hide elephants in mouse holes. So think about that for a minute. What he's saying, and I think specifically applies to the Clean Power Plan, where 2 paragraphs, a mouse hole in the statute, are by EPA's own admission being used to transform our energy economy without any new significant legislative enactment from Congress. And so the court, I believe, is also forecasting what might occur if this type of rule ultimately gets to them, and they did so in 2014 in the Utility Air Regulatory Group case of 2014. And there, the majority said, when we expect Congress to speak clearly if it wishes to assign an agency decisions of vast economic and political significance. Again, that no doubt will be in many of the briefs, and it probably already is in the briefs filed in the Clean Power Plan case, and we will see what the court does with that. But there's no question in my mind that this is a vast economic and regulation with very significant political impacts. So, but I want to talk a little bit more about the WOTUS rulemaking, the Waters of the United States and Clean Power Plan, but I want to remind you, why did Congress, in its wisdom, put states in the primary role of implementing environmental laws in the first place? And this is where my state experience comes in. And I submit to you there's three basic reasons. There's probably a lot when you start to add them all up. But here in Florida, what I've seen is that the states inherently are much more nimble than the federal government. They have, first of all, virtual plenary authority to implement environmental regulation. So they don't have the handcuffs that the feds do in terms of how far they can go within their Congress power, if those indeed are any limitations at all. States don't have those. State agencies, the one that I was at, and I saw many others, are able to turn issues around quickly, whereas at the federal level, bureaucratic and organizational changes are very difficult to make because of politics and a lot of other reasons, institutional reasons. Just a few examples from Florida. Under Governor Scott's leadership, DEP went through, as did all the agencies, and went and evaluated how many regulations are outdated, unnecessary, and we ended up cutting 1/3 of all regulations on the books at DEP. Or to take another instance, Governor Scott was able to do something that the feds have never been able to do, which is eliminate an agency. He decided when he saw the lay of the land after becoming governor that the Department of Community Affairs, which was the state's primary land use regulation authority that was created in 1969, was actually unnecessary. In 1969, there were very few counties, only the big counties in Florida had the privilege of having city planners and land use planners on staff. Well, now virtually every county in the state has that, and Governor Scott rightly recognized that the need for a statewide oversight and micromanagement was not necessary, and while some statewide aspects still are in place, the majority of that has been shifted to the local level, where decisions can be made that affect the issues they're facing. I think states have been more successful than the federal government at harmonizing these regulatory and bureaucratic issues. Even President Obama has rightfully recognized how the feds struggle in this respect when he pointed out in the State of the Union address that salmon regulation, the salmon fishery, is regulated by two federal agencies. One, when salmon are in salt water, and then the other, the Fish and Wildlife Service takes over when they come to spawn and they're in freshwater. So it seems overly bureaucratic, and to my knowledge, nothing's been done to change that framework. Even though the president, I believe, made a very good observation on that point. Second, states are closer to the environmental challenges and better at crafting solutions because they're in their own backyard. Take, for instance, Avi mentioned the numeric nutrient criteria. That's when Florida put a number on what level of nutrients can be in a water body in the state of Florida. Well, what we found was that a number wasn't enough at times, and we needed biological verification because some water bodies were healthier with a higher numeric limit. Nutrients are key for life, and and we wanted people to verify, and not just by a number on a page, but actually have scientists verify whether a water body could tolerate a higher numeric limit and actually function and have the functions of a wetland system or a water body. And I'll brag on our state for a moment, and since Avi also mentioned Everglades, the Everglades Restoration Project is the largest wetland redevelopment project in the world. It was when it was entered into, it was supposed to cost $8 billion. Now it's over $10 billion. The state has spent over $2.5 billion, and Governor Scott has committed even more. And initially, it was supposed to be a 50-50 partnership between the state and the federal government, but the feds have fallen way behind in the funding, and the state of Florida is really out in the lead. And in the air world, Florida cut its greenhouse gas emissions by 20% since 2005, simply for economic reasons, because natural gas was cheaper and more efficient in running plants than coal was. So I just want to, and then the third reason that I'm submitting to you the states do it better is state agencies have a much greater level of accountability than the federal government. And this gets into an institutional legal issue, which we can discuss about whether deference to federal agency rulemaking is proper or is in need of reform. And here in Florida, we have an Administrative Procedure Act that has very stringent levels of oversight by our state legislature, and as well as legal checks that ensure that there's the bounds of agency decision-making are well-cabined, and they're not able to take relatively scant statutory authority and transform it into a whole new regulatory framework. But by comparison, under Chevron, the Natural Resources Defense Council case in '84, the Supreme Court basically said that if a statute's ambiguous, that they will generally defer to the agency construction of the statute rather than have the court itself reinterpret and read the statute themselves and apply its own interpretation. I'll make the point that it's very important to have agencies making complex scientific decisions in areas of their expertise. However, I would submit that a court is equally able to interpret a statute, and sometimes better, than the agency or a federal agency. And some are calling for the court to re-examine whether the Chevron deference standard is still the proper standard for how we evaluate our federal agency rulemaking. So we've talked a little bit about the waters of the United States. I want to make a point in particular, and that is the one why the federal government should consider and put more weight on place-based regulation. In Florida, as you know, we're a very wet state, we're a very flat state. And the floodplains in Florida are incredibly broad, and our groundwater levels in many places around the state are just a few feet under the surface, if that. And take that and compare to a state like Colorado, where a floodplain for a river might be very small. So in Colorado, the Waters of the United States rule may not regulate very much land, versus in Florida, if EPA is talking about using the FEMA flood maps as their basis for determining what a watershed is, those flood maps cover virtually the entire state. So the question is, does the Waters of the United States, as applied in Florida, become a de facto land use regulation, which historically has always, regulation of land use has always been understood to be the province of the states. And now to develop on my own property, I need to seek a federal permit in order to do that. And I will point out, Florida, we already have a wetlands permitting program in place, that we have a no net loss of wetlands policy under state law that is perfectly capable and active of regulating the same issue that the feds are attempting to regulate. And I think because one area where cooperative federalism needs to get better is more delegation to the states that are doing it right, like Florida. And then, as my second example of how the Clean Power Plan rulemaking is starting to encroach on state authority, bear with me here, but it's a little bit technical. But EPA basically has three building blocks for how that rulemaking is structured. First, they ask utilities electrical generating units that exist to increase their efficiency by essentially increasing their heat rate. Second, they ask the utilities under building block 2 to substitute coal-fired generation for natural gas generation, and change the dispatch of energy, so start running plants that are gas-fired and more efficient, and therefore you get less carbon emissions. And then 3, they start asking states to do more renewable energy generation. Let me just focus in on that building block 2, and that's another area. Dispatch of energy has always traditionally been regulated by the states, and our Public Service Commission has regulated heat rate and been in an area, has always regulated that area. And under the Clean Power Plan, the catchphrase that is going around is that they regulate outside the fence, and they're regulating things that aren't within the boundaries of the power plant and where the emissions are historically been regulated under the Clean Air Act. So I think there's solutions to these issues. We've seen a lot of them in our State Administrative Procedure Act, and there are things like legislative ratification of rules, and I'd be happy to talk about that more as the conversation continues. But that's the reasons why I think states really have the tools that they need to regulate some of these important issues. So thank you.
Thank you, Matt. Environmental law is so complex that we could talk about this for hours. Unfortunately, we're approaching the 4 o'clock hour, and we're supposed to finish pretty close to the 4 o'clock hour. So I really am going to limit this to, I'm going to ask one question with 2 subparts to the panel, and then find out if there's a question or 2 from the audience, and then we'll conclude the program, because we're really running out of time, unfortunately. But it's been a great panel, and there's just a huge brain trust of environmental law up here on this panel, and I hope that everybody is grateful to them for their contribution here today, because it's been very interesting, and I really appreciate everybody's participation on the panel. My question is, and it's got 2 subparts: is environmental law meaningfully different from other areas of governance under a federalism framework? And if it is different, then should we allocate state and federal environmental authority according to different metrics than we do in the context of other arenas? For example, in the health law area, where there's obviously overlap in the states between who's in charge of what, immigration law, and other areas of jurisdictional overlap. And if it is not, then can the structures of governance developed in environmental federalism serve as models for other areas? And I'll start with the professor.
I'd be delighted to talk about this, but I think it's probably more interesting to hear from the practitioners on this case. So
Okay.
I'm happy to stand in, but cede the floor.
All right, so we'll defer. We'll open up with Patrick then.
Well, I'll briefly address it, although I think that Avi is the one who probably discuss it.
Okay.
But no, the point I would make on this actually is environmental is a different subject matter. But I mean, and I don't mean to be, a little sort of narrow in focus, but we're talking about a limited federal government with limited constitutional powers. So I guess at the end of the day, no matter what the subject matter is, the question should be, what is within the scope of the powers that are delegated to the federal government versus the state government? So environmental effects may be somewhat unique, but at the end of the day, we're talking about whether or not there's a meaningful link with interstate commerce. And so I guess my answer would be it should be the same to the extent that the effects can be tied to interstate commerce, whether we're talking about healthcare or other effects. Trying to keep it short. Avi, do you have any input on this?
Well, I guess, I appreciate it. I guess, for me, a lot of the conversation, and certainly the last question, boils down to whether we're asking ourselves about how these laws should be or how they currently are. And as to the first question, I guess, notwithstanding Professor Ryan's kind of deference to me and to others, I'd like to leave the kind of question about whether there is a different structure that could be more effective or more deferential or more meaningful to others. But in terms of kind of how it is, for me the question is it working? Could it be changed? Is there a proper allocation of power, of resources, of proximity to the problem? I would suggest respectfully that we take the laws as they are. EPA gets its authority from the law, it's checked by the courts, and it does me and the agency no good to quote-unquote overreach when we know we're going to get litigated, and the courts will hopefully take a look at that. So the way in which we judge our actions at the agency are we proceeding in line with the statutes as they are written, with the allocation of responsibilities and functions and power, et cetera, as Congress wanted them to be. My sense of things, Judge, is that we're actually at a very good place. Again, I know that there are some differences of opinion, certainly on the panel, and perhaps with myself, on the Clean Power Plan or the Clean Water Rule. Many of those matters and others are currently in litigation. And so, we feel confident, but we'll see how the courts proceed in that regard. But my overriding sense is that the relationship between local and state regulatory authorities and the exercise of the EPA's responsibilities on the federal level has, over the past many decades, been highly effective and kind of adhered to the rule of law. I will just mention, and it's a difficult subject certainly for me and the city of Flint. That's been a very critical thing that we've worked on. And so you think about, and Matt talked about, all of the crises that led to some of the enactments in the early 70s of these statutes, and as effective as we have been, both at the state government and the federal government, I don't want any of us to forget that we still have crises, we still have dangers, environmental endangerments that need to be addressed not only at the state level, but also at times with the backstop of the federal authorities. So, periodically, and I think unfortunately, we're reminded about the wisdom, if you will, of that cooperative federalist structure that kind of is built into our statute. So I think by and large it's working. I'm really not qualified to compare it to other areas of law, and we'll strive to improve it, but I think we've got a very good cooperative federalist partnership going.
Okay, thank you, Avi. I'm going to give Matt Leopold the last word, and then what we're going to do, since we've run out of time, is the panelists will stay behind if there are any members of the audience that have any questions. But I'm going to go ahead and conclude the panel so that we finish on time. And then the panelists will stay behind if there's anybody that really has a pressing question, and we'll be glad to answer the questions after we've concluded the panel. Matt, let me give you the last word on that questions.
Okay, I appreciate that. I also don't know if I'm qualified to compare environmental law to other areas of law, but I will say the principles of additional checks on regulatory processes in the federal government apply broadly. Our Federal Administrative Procedure Act hasn't been meaningfully updated since 1946. And I think that is the area that Congress can start to work together for enormous rules with transformative impact that agencies propose. I think we need congressional ratification of those, and we can argue about at what threshold. But we've got to start incorporating cost-benefit analysis at a greater level, and even the Supreme Court recently in the Michigan case told the EPA that and remanded the case back to the rule back to EPA for additional consideration. But I'll end with this. EPA noted on their website the day after they lost that case in the court that over 90% of that rule had been implemented by the industry. And industry, and what I've learned in being in the state, industry can't wait around to see whether the rule is going to be upheld by the court or not. They have to plan long-term, particularly the utility industry. They make multi-million-dollar investments, and the lawyers can wrangle, but for greater certainty for the business community and the regulated community, we've got to reform this area of the law.
Thank you. I want to thank Avi Garbow, Matt Leopold, Patrick Strawbridge, and Professor Erin Ryan for participating on this panel. I want to thank everyone for being here. We're going to go ahead and conclude the panel now. And as I said, the panelists will stay behind. And if there's any questions from the audience, we will be glad to answer those questions.